car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis, Wright.
Hi, glad to have you with us here on The Attorneys. I'm Mark Franklin, your host. Today we are giving you some good information on industrial accidents, and there is really a lot to share. Let's get right to it as we get to a managing partner over here, Josh Wright, and John Spade, also with Hollis Wright. Got some good news to share in that regard.
Absolutely. So John, of course, has been with us for many years, has just accepted a partnership with our partnership, and we're so very excited to have him on today to talk about co-employee litigation, but also to be able to call him my partner.
That's
In
right.
fact, I had a conference call the other day, and I noticed he started smiling when I mentioned on the conference call that this is my partner, John Spade, and I was like, that's a good sign. That's a good sign.
It's still very excited to be here. Been with Hollis Wright for a long time, and the partner title is still kind of sinking in. It hasn't quite sunk in yet, but happy to be here and happy to be on the show today too.
Yeah.
We got a good topic. So.
All right, so one of the things that I mentioned to Art before we started was that you and I have handled these type cases forever. Let's just kind of unwrap this topic a little bit and just unpackage it. Really what we're talking about is workplace-related injuries where someone may have, for example, workers' compensation, where they need to deal with one of our workers' compensation lawyers. But also, we investigate those claims to assess whether or not someone may have another theory against a third party or against their own co-employees related to a defective product, a piece of equipment, the removal of a guard, for example, that may have caused their injury. Is that a fair assessment of where we are?
That is, and that's what we're going to dive down on, the removal of the safety guard, which is one of those avenues where you can have that claim against either a co-employee or a supervising employee or, potentially, an OSHA individual. There's a lot. We'll kind of talk about that as we go out throughout the show. We've done, shows on workers' compensation. We handle those cases. This is a kind of a subset of that, but it opens up your ability to get some additional damages, and it's a very nuanced area of the law, so we're going to kind of dive down a little bit on that. It does kind of tend to work hand in hand with some workers' compensation. We'll have, that claim will be kind of alongside this, but this is against a different individual. Whereas your workers' compensation, you're under the Workers' Compensation Act. You've got a schedule of injuries, and that was codified back in the early 80s, and hasn't really been changed a whole lot since then. What we're talking about is this removal of a safety guard, which is a C2 claim. And we're going to kind of unpack that a little bit as we go out today.
I think it's important if you're going to be a law firm that provides services in the area of workers' compensation, that you're also able to evaluate the claims for additional potential damages the person may be entitled to under both the workers' comp statute and against third parties that may have contributed to the injury. We're not talking about the run-of-the-mill accident where someone has, consistent back pain or has broken a finger or, has a fracture because of repetitive use. We're talking about significant injury claims that need to be evaluated to make sure that person's fully compensated, because no disrespect to the workers' comp statute, but the workers' comp statute is not really going to be able to put the worker back to the full position that they were in beforehand financially. So there are other ways that you can do that through other claims.
And really want to get into some of those injuries, those workplace injuries. But one thing I did check before we did the show was to look at what was happening in Alabama and check the U.S. Department of Labor statistics, and it shows that those workplace injuries in Alabama are on the rise. So if we can kind of set the stage of kind of how they govern workplace safety in the first place before we kind of get into some of those injuries.
Yeah, feel free.
Yeah, so you've got OSHA standards, and the employer has got to provide a safe working environment for their employees. And a lot of times when we're looking at these co-employee cases, they're happening in an industrial setting. on an assembly line, somebody's kind of doing a repetitive motion with like a saw, for instance, cutting the same cut over and over and over again. And the manufacturer of that machine will provide a guard or some sort of a safety device to prevent injury of the employee or of the worker. And so this will happen in those types of settings. Sometimes we see them outside of the industrial accident setting, but most of the time it's in that industrial setting. So like Josh alluded to a little while ago, we've got this workers' compensation law. But we've got these workplace injuries that are unfortunately on the rise. And while you can have recovery through the workers' compensation, you can also have, if the facts fit, and you've got to really, kind of dig into the facts and evaluate these cases to see if they meet all of the criteria, you can have this additional claim against a co-employee or against a supervising employee. So they work hand in hand. We've got some protections there in place, but you've got to kind of fit and go through some of this criteria.
And let's take an example. You mentioned saw earlier. Let's take in an assembly line or in a industrial setting where someone is responsible, for example, using a commercial grade saw that has a guard over it. What we're really talking about related to these co-employee claims and the removal of a safety guard is not just the removal of a guard. It can also be the failure to maintain that guard, failure to service that guard, and those types of things in addition. Fair?
Yeah, absolutely. And also, failure to install it initially. If the manufacturer sends a guard and the end user puts everything together and they just leave off the guard, that could be a claim too. And so it can get a bit technical as far as who is the manufacturer, that sort of stuff. But if you're making material alterations to that machine, you can in fact, the employer can become the manufacturer of that machine, and then we can pursue a claim that way. So yeah, there's a lot of different avenues. Failure to maintain is certainly a big one. Failure to install is another. So there's a lot of different things to look at when you're evaluating these.
And Art, let's think of it this way. This is actually a real-world case that John and I are working together right now. Companies have a responsibility when they have equipment, especially equipment that's dangerous that requires guarding to prevent injury to an employee. They have a duty and responsibility to maintain that equipment. They have a duty and responsibility to do preventative maintenance and to be able to have a process in place that complies with the manufacturer who set up that machine with certain guarding, that the machine is going to operate in that process to make sure that it's safe for the employee. And when they deviate from preventative maintenance, they deviate from properly fixing, or they deviate in the guarding that was originally intended by the manufacturer, they can be responsible for an injury that is caused related to that.
Is there a trend that you're seeing right now in terms of workplace accidents?
They're on the rise, but I mean, as you mentioned.
Yeah,
they certainly are, and really in the last, probably 3 to 5, 7 years, we've kind of seen an uptick, and there's not a ton of law firms out there, to be honest, in the state of Alabama that are handling these cases, because it is, very nuanced, and you have to know the statute, and more importantly, know the case law that's interpreting the statute. But we're seeing more and more of these accidents, and if you suffer an on-the-job injury and you go to a workers' compensation, attorney to represent you, it's important for the viewers to be asking these questions and having this thought process and thinking through, hey, this was an industrial type accident. I was injured by a machine. Are there potential other avenues to help the person out? Because if you're stuck with just comp, and again, no disrespect to the comp statute, but it is very outdated, something that was, the schedules were put in place years and years ago and haven't really adjusted a whole lot, I think, for inflation and for kind of where, we're seeing, verdicts and everything now. You can potentially get additional damages under this.
And I would argue, I know we're about to go to break, and I want to talk about the elements necessary to prove when we come back, but I would argue that as far as law firms in Alabama that handle both workers' comp, but also evaluate every one of those cases to determine if there's a third-party case or additional coverage through a co-employee lawsuit. We're one of the only ones out there that does this. In fact, John and I go across the state, and we teach other lawyers how to evaluate third-party litigation and co-employee cases. So if you want a full-rounded evaluation, you need to come to a firm that does full-rounded litigation in protecting employees.
So still a lot to unpack on workplace injuries. John Spade is here, of course. Josh Wright, as we continue to break that all down. But I want to remind you, you can get in contact with Hollis Wright. There is a QR code on your television set right now. Scan it with your smartphone, and you will get in contact with someone at Hollis Wright. You can also make that call, 1-844-LAW-TALK. Hollis Wright attorney will talk with you. It is a free call. It's also confidential. No one has to know what you talk about, but they will answer your call right now. So make that call. We're going to take a break, and we'll continue on with workplace accidents when we come back. Stay with us.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
Front Porch Alabama is a first-of-its-kind website for shopping Alabama's boutiques, artists, and makers. We promote Shop Local on a statewide basis. We've discovered so many hidden gems in the retail world in Alabama, and we bring them to you right on your phone or your laptop.
State Traditions is an apparel company. As soon as I heard about the concept of Front Porch Alabama, I knew that that was something that we wanted to be a part of. And Front Porch Alabama allows us to reach customers that we would not reach otherwise.
Front Porch Alabama has such a wide variety of products from all across the state. I've got 2 girls that go to college, and I love picking out unique game day outfits for them. And if I find something that I love, I can just click and purchase right on my phone. It's super easy.
Start shopping at frontporchalabama.com today.
Hollis Wright has been handling workplace injury cases for years. If you've been injured on the job, give us a call. Our attorneys are standing by right now to give you a free consultation. And remember, at Hollis Wright, your result matters.
And welcome back to The Attorneys. You know, there are many ways you can reach someone at Hollis Wright. Follow Hollis Wright on all the social media platforms. You can do that on Instagram, on Facebook, and also on X, formerly known as Twitter, of course. But we're talking about workplace accidents. We know they're on the rise in Alabama, but you wanted to get into some other nuances about it.
Yeah, and so obviously we're outside of the comp context. It's another way to be able to recoup for your injury in a serious injury case in an industrial accident. And just explain, if you will, why it's important to consider a third-party case as it relates to the damage you can get in those cases versus workers' comp.
And we touched upon it a little bit before the break. When you've got that workers' comp, you're under that statute and you're under that schedule. When you have a co-employee case and the removal safety guard, which is what we're talking about today, you open yourself up to the ability to pursue damages just like you would any other personal injury case. So, medical bills are recoverable. Pain and suffering, which is not recoverable under workers' compensation, you can get that damage. And a lot of these subcategories under the statute, there's a willful intent there. And so if you can prove that, you can potentially get punitive damages as well as recoverable, which also is not available under workers' compensation. So, we do a lot of shows on, car accidents and premises liability and construction, and fall cases. You get all of those types of damages that you would not otherwise get if you're traveling only under workers' compensation.
And talk just generally, and I know the statute itself is a little complicated, but in general terms, what elements do you have to prove in order to be successful on either the removal or the failure to repair or the failure to maintain a safety guard that caused someone's injury?
Right, so you have to have a safety guard that was provided by the manufacturer, and then the safety guard has to be removed, it has to not be installed, it has to not be properly maintained, it has to be taken off the machine in some way, and that the removal had to occur, at least under the C2 claims that we're talking about today, had to occur with the knowledge that the injury would probably or likely result. Now that doesn't mean, and there's a lot of case law, and I know we've spent a lot of time going through this here in the last couple of years, you don't have to have an intent to injure somebody by taking off that safety guard device, only that it was removed and that an injury would likely or probably occur. And then there's a causation factor, of course, as well to that as well.
And here's the thing, if you have a serious injury related to a workplace accident, you don't want to try and do this on your own. And people are smart enough to recognize that. You want to go to someone like John that can evaluate your case, understand what the elements are, plug the facts of your injury into those elements and determine whether or not you've got a claim. And John will tell you, hey, you have a claim under the following circumstances, but we're going to have to prove X, Y, and Z to do it. So you want someone to lead, guide, and direct you through that process.
Someone who really understands. And when I'm thinking about the workplace today, so many technological advances have been made. Are there new risks in the workplace that you have to deal with as well?
Absolutely, and with the changing and altering of even like some of the safety guards and having the technology, you can have defects in those new technologies. And so we talked about, the failure to maintain. You got to make sure that if it is an automated system, an automated safety guard, that it's working properly. And so that you have to do that preventative maintenance, whether it be, 30 days, 60 days, 90 days, whatever it is, to make sure that these new technologies, these new automated machines are working the way that they should. They're calibrated correctly, all of that. So, technology is great. It helps us every single day. It's terrible when it doesn't work right, but you need to make sure if you are doing those automations and as we kind of evolve, from a technology standpoint, that everything's working correctly. And that's where that failure to maintain and properly, look after those safety guards is really important.
And Art, let me give you a couple examples of actual cases that we have that will highlight what we look for. It's not just the traditional guard that you think about is, one of these yellow fabricated steel guards that covers a blade or covers a moving fan that you don't want to get your hand into. Mm-hmm. Guards come in all sorts of shapes, colors, and sizes, right? And I mean that figuratively. Sometimes it is a gate that if you're going to go into a dangerous area and you open the gate, that gate has a connected interlock that when you open it, it shuts all the machinery down. Sometimes it may be as simple as a locking mechanism on a component that it is supposed to lock while you're using the component. A good example could be a door lock on a commercial vehicle that has been changed by the employer or employees of that employment that allowed that door to open up. It can come in a lot of different ways that you don't generally recognize. And one of the things that I think is important is to make sure you get a lawyer involved to identify whether or not that truly even falls into the category of a safety guard that is actionable for your injury. And people may be sitting and saying, I hear these concepts. This is kind of a complicated topic. I don't really know where to start. Let me tell you where you start. If you had a bad injury, you want to talk with someone and let them evaluate it for you. And sometimes it comes to that simple. Someone called me the other day and said, hey, I've heard this concept. I've even read something on your website about a co-employee case. I don't understand it. It's really more complicated. Tell me what I need to look for. I said, well, how bad is your injury? And they explained it. And I said, explain to me the process you were using. And he said, here's the process. I said, come see me and let's work our way through this. And that's a case ultimately that we're going to sign up because it actually is a safety guard that was removed that falls outside the traditional fabricated safety guard you see. That is an actionable claim where that person, where their comp case may have been worth $50,000, their real claim could be worth millions. right? So it all comes down to getting to the right law firm at the right time.
And just to kind of round that out a little bit and put a pin on it, remember, at the end of the day, the consultations are free. And so it doesn't hurt you if you're sitting out there saying, I don't know, I mean, this and that happened. It's worth a call. Worst that can happen is it's not something that we can handle, and if it isn't, then we'll let you know that. But it doesn't cost you anything to pick up the phone and call. So just kind of round out it is very specialized, and we do handle these types of cases every day. It's nothing off for you to pick up the phone and call.
Alabama has something called contributory negligence, and when we come back from the break, because I know we're about to go there, I want to talk about why it's really important to consider a co-employee case and why you want to look at the removal of a safety guard and how it applies, even if you as the employee has some contribution to your accident, whether or not that even matters in a co-employee case. And John can unwrap that for us. And I think employers are going to look at it and say, okay, this is worth a call. So
go ahead and put a pin on that right now. We're going to take a break and we're going to unravel that when we come back. I want to remind you, though, you can still get in contact right now. Lawyers are still taking your call at Hollis Wright. Call 1-844-LAW-TALK so you can talk to someone there, get a free confidential call. But we still have a lot more to get into when we come back. Stay with us. The Attorneys continues after this.
Thank you for watching The Attorneys each Sunday night, where we come to your living room to provide free legal advice in a confidential, off-air setting. Unfortunately, with the number of calls, texts, and emails that come in during the show, we can't always get to everything. But know this, Hollis Wright is open all week long. You call us at 844-LAW-TALK and we're going to answer your question for free. Thank you for watching The Attorneys, and we look forward to seeing you and talking to you soon. We love this state and its great people. People that are worth fighting for in their lowest moments. It's what drives our lawyers to do what we do. We're here right now to fight for you. At Hollis Wright, your result matters.
And welcome back to The Attorneys. We asked you to put a pin on something before we left for break, and we're going to pick it up right there as we continue to talk about this industrial accidents, because it's really on the rise in Alabama, and we want to kind of unpack that for you.
Yes, so John, talk a little bit about, in general terms, how contributory negligence works if someone contributes to their injury and the impact that it has on their case versus in a co-employee setting.
Yeah, so we talk about contributory negligence a lot, on this show. It's a very, very harsh effect on a personal injury claim. We're one of the few states in the country that have it. If the injured, person is found to be even 1% at fault, it's a complete bar to the recovery. Now, I think in real practice, when a jury's back there deliberating, I think that they still kind of do a comparative type analysis a lot of times. But the rule is 1% at fault, your recovery is zero. That does not apply to workers' compensation cases. It's a no-fault system. Which can be very beneficial for injured workers. A lot of times, pre-workers' compensation statute, a lot of these cases were going out on contributory negligence because if they somehow the injured employee removed the safety guard themselves or did something they weren't supposed to do on the job and got injured, well, their recovery was zero. And so to kind of weigh that out and balance that out, that's where the workers' compensation statute came in. Now, these removal of safety guard were under the workers' compensation statute. They are a statutory claim, which is important. And the contributory negligence and those harsh effects of the contributory negligence don't apply to these types of cases. Unlike a Contributory negligence in its name is a contributory negligence. It applies to a negligence claim and in response to a negligence claim. If you claim that somebody was negligent, they can say, well, you contributed, you were also negligent, and so you can't recover anything. This is a statutory claim, and so it's different in that respect. And the language of the statute does have a willfulness in there. We talked about the elements that you have to meet earlier. So you're not saying that somebody negligently removed a safety guard, that they willfully removed a safety guard. So, the contributory negligence does not apply in these situations, despite, many employers, manufacturers, co-employees wanting it to. It just doesn't.
So, let's take some practical examples of things that we are actually seeing in cases that we handle. We talked about a commercial grade saw that has a guard on it. If the guard is not working because there's a defect in the guard itself where the guard allows the blade to come below the guard, it creates a hazard. We have a case like that right now where someone almost cut their entire hand off because of that. That's an example. We have presses. That are commercial grade presses that are machines that press down cardboard or other various commercial materials to compress them to be able to either sell them for scrap or to have them hauled off. Those presses are not one component. They are a hydraulic push, and they're a platen that is the pressing component. And those two are connected through a series of safety guards, including anti-vibration nuts and bolts that don't come off after you cycle over and over and over again. Pins that are supposed to be strong enough to hold those two things together. That's another example. A further example is interlocks, where you open a gate, you don't realize you're in a dangerous location, and all of a sudden you have baggy clothes on and your sleeve gets caught in an inward nip point and it sucks you into the machine. You'd be amazed. We have all these cases, and I've seen them for years, where there are catastrophic injuries, lost foot, lost leg, brain injury, paralysis, death. Those are all things that we see based on the safety guards not properly working. And so, again, it's important to get with someone early on to be able to evaluate these cases. You want to go to a firm that's able to do that.
I'm wondering what kind of challenges you guys face when representing someone with a claim like that.
There are tons, and there are tons of pitfalls in these cases. And one thing that we always talk to our clients about, even on the front end and throughout the entire case, is these can be very factually intensive cases. They're very document-heavy cases. They require expert witnesses to testify, and the cases do evolve, sometimes for the better, sometimes for the worse, as the case progresses throughout litigation. And so there are a lot of pitfalls that you have to look out for, and you have to go into these cases with that mindset that there are a lot of work, but you're talking about an injury that is very significant, and so the reward for our clients is there. So it's worth doing that on the front end and navigating those pitfalls.
And one other thing too, Art, to mention is our law firm specializes in evaluating whether there is an independent third-party insurance company involved in these cases that is defending the employees who were, for example, in maintenance or supervisors related to the guards, or, for example, companies that are self-insured themselves. And we do that for you, and we work you through that process to make sure that your claim is covered. Good job, by the way. Thanks for being on.
Thanks for having me.
Hey, congratulations, too, again.
Appreciate it.
So you knew where to turn to get some good information tonight about workplace accidents, and you know where to go now if you have a claim. Go to Hollis Wright. We're going to remind you also to join us next week for another edition of Hollis Wright. We'll see you back here, same place, same time. Have a good night.
Thanks for watching The Attorneys, sponsored by Hollis Wright.